The next case number, 122713, State of Kansas versus Brennan Trass. Counsel, would you please come forward? Perkins?
May it please the court, Clayton Perkins of the Capitol Appellate Defender Office, appearing on behalf of the defendant appellant Brennan Trass. I would request 3 minutes for rebuttal.
Thank you, Mr. Perkins.
And I'd like to start with issue 2 today, which is the in the initial appellant's brief, which is the denial of the right to counsel issue. And I would start with a note that last week was the 61st anniversary of Gideon v. Wainwright, which I cite in that brief for the notion that a defendant has a right to counsel at trial, which is one of the critical stages of the proceedings where Mr. Trass was denied the right to counsel, though it includes other critical stages such as the suppression hearings, pretrial hearings, and indeed the limited proceedings on his waiver of the right to counsel, where he was uncounseled. And I think there are 2 angles to think about this issue. The first being the lack of the knowing, voluntary, intelligent, and indeed competent waiver and the proceedings required under FRERETA or the FRERETA inquiry requirements. And then second is the insufficient support of the waiver by conduct to sort of invoke that. And
would you weave into that, for me at least, more of a discussion about forfeiture?
Certainly. And I think there are, Kansas has not recognized this in its case law, and these are, or at least not expressly, and in other jurisdictions, some of them discuss just a waiver by counsel. I think there can, at least philosophically, be and have been discussed 3 sort of types of waiver. We, of course, have the actual voluntary verbal request for the waiver of the right to counsel. We have waiver by conduct of the right to counsel, which is sort of using the conduct of the defendant as the replacement for the verbal desire to proceed without counsel. And then there is a concept that has been recognized in some jurisdictions of forfeiture of the right to counsel, which is in cases of extreme misconduct where the defendant may forfeit that. And that's usually come up in situations that involve physical violence or threat of physical violence against counsel. And we have nowhere near that situation occurring in this case.
But on an insufficient, on a waiver of conduct, and how you're relating it to a FRERETA waiver, it is still, you assess that still for voluntariness, correct?
Mm-hmm.
And then isn't necessarily implicit within that a warning, right? Because you'd have to, waive it. Okay, if you engage in this conduct again, then, you're not going to have counsel. And so then you engage in it again, and those are the consequences, right?
Yes.
Okay, so where does it fit in the whole concept of here, let me let you know what you're doing by waiving. You are, it's really hard. You're going to be in prison or in jail, and so you can't subpoena. And it's going to be really hard because you may not understand the rules of the evidence, and it's going to be really hard because you haven't gone to law school, and it's going to be, the 10 things about how hard it is to represent yourself. Now, is that in a forfeiture situation where it's involuntary because you've never been warned, or even in a waiver by conduct, where does that fit in?
Under all of those, I think the protections and requirements of FRERETA and that case law still apply, and still should apply. FRERETA is, quite clear that a defendant needs to proceed to pro se representation with their eyes open to the dangers and disadvantages of proceeding in such a way. We have, of course, case law elaborating on those standards, talking about the requirements upon the district court to ensure that the court advise the defendant of the right to counsel and appointed counsel, that they possess the intelligence and capacity and indeed the competency to self-represent.
Those are those cases all under like the Ferretta waiver? Or do we have any cases waiver by conduct on those in Kansas?
Not clearly.
Okay.
And indeed, the unpublished opinions, the Jones and Landeo opinions that I cite and discuss, and indeed came up in this case, or at least the Jones one did in the proceedings, are really the limited authority.
Okay.
And
then finally, so it's your position, and I want to make sure I understand what your position is, as Justice Biles asked. Your position is this is not a forfeiture case. This is a waiver by conduct, and you want that measured by whether it was voluntary and intelligent waiver by conduct.
yes,
What are we supposed to do though with, I mean, your client went through 7 sets of lawyers. And at the last set, he was told by the judge, clearly had lost her patience, I think. Was told by the judge, I don't have any more lawyers. And he continued to believe, I guess, that the lawyers are conspiring with the state to throw him in jail. And it just seems like we're in an impossible situation. The district court, the trial court's in an impossible situation, other than to say, all right, buddy, you know, you're now representing yourself. That, and push back with me. But I'm just saying, it doesn't seem that unreasonable up to that point.
so I certainly recognize that this is a frustrating situation, and particularly combining with attorney shortages. The attorney shortages should not be the consideration here about whether or not a client gets a right to counsel, because it's hard to find the counsel to appoint. That right still
How do you
persists,
solve
but
that problem? He's not happy with anybody. I mean, might be happy with you, but I don't know how much contact you've had with him. But set that aside for a moment, or maybe we'll send you back to Reno County, but.
Mr. Perkins, is that even the issue here, though? Is the issue that that was her discretion to do that? It's just the procedural guardrails weren't followed? Is that the issue? Or is the issue whether what Judge Biles is saying, that is the issue she shouldn't have done that? Or is the issue if she was going to do that, she needed to follow the constitutional guardrails?
I think there is a bit of both there. She needed to file the constitutional guardrails. This is not a discretionary question of whether or not the Constitution, the Sixth Amendment, FREDA, and those requirements are met. That's required. This court's made very clearly that that is incumbent upon the district court to ensure that is protected. I quote State v. Hughes, where it is not up to the defendant to know what fully advised means. It is the judge who is burdened with assuring that the defendant's rights have been adequately protected. There is of course, this court has long recognized a strong presumption against the waiver of the right to counsel. Those rights do not go away in a frustrating situation. I do recognize that this was a difficult situation. It had gone through many counsel, not all of which was Mr. Trass's fault. Some of them had co-defendant conflicts. His initial public defender's office failed to provide him information on a plea agreement or a plea offer, which he had a constitutional right to, which caused a breakdown of that relationship. He also was not in this sort of other situations where we see where it's fully dilatory or hostile conduct. He had worked with his last defense team for 9 months, and they had generally had a good relationship until reaching this breaking point, but like
2
many,
weeks before trial.
2 weeks before trial, yes.
Can I get a sequence of events here? And because it is hard to follow, I've tried to track each council. But last council that was appointed was, and I'm not sure how to pronounce it, Hebert?
I believe so, yes.
Hebert and Centeno, or I'm not sure how to pronounce their
Yes.
names. They were representing your client. And then at some point, they became frustrated and asked to withdraw. And the district court judge, she said, yes, it's obvious this is a contentious relationship. I'm gonna allow you to, basically finding a conflict, and I'm gonna allow you to withdraw. And then after that, Mr. Trass was representing himself in court, and then for a variety of reasons, forfeited his right to appear in court. And then for the remainder of the trial, Mr. Hebert was reappointed, or what happened there? Wasn't he the counsel that followed up and continued the case
Yeah.
in your client's absence?
Yes, at the instructions and closing argument phase.
And so there was a conflict, but he appointed conflicted counsel?
Which is inappropriate, and I believe is issue 3 in our brief, that.
I just wanted to understand the sequence of events here.
Yes.
So ultimately, it ended up with your client had a lawyer that there'd been found to be a conflict. I just wanted to understand that.
That's the question about that. One of the lawyers, as I went through this, because it's a large record, one of the lawyers, there was a perceived conflict that the judge found was not a conflict, I guess, that the lawyer was evicting his mother and sister from where they were staying. Which, was that the Hebert lawyer?
No, that was Miss Crane.
Okay.
Can I ask another follow-up?
Yes.
On this topic? And what I'm focused on is the district court's ruling. And the portion of the ruling where, as I read it, the district court says that the district court has conferred with the head of bids and basically been told, quote, I have no options for appointment. And she, that is the head of bids, has confirmed to me my ability to require the defendant to represent himself. That's an interesting statement from the judge. It appears that not only was the judge frustrated, but bids itself had become so frustrated with this client that bids is basically saying, I'm not going to give you anybody else to appoint. And I think you should just require him to proceed pro se. How do we weigh? I don't even know how to weigh that in the analysis.
I don't, beyond the fact that difficulties in finding counsel should not be a consideration in here, I don't think you give it much weight.
Well, it's not just difficulties, it's you have the public agency tasked with providing attorneys to indigent defendants saying, not only am I not going to give you anyone else, you should just go ahead and exercise your discretion to make him proceed pro se.
One, we don't have the full context of that conversation. It's not the role of the director of the public defender services of our state to say there isn't counsel for people. It's their role to find counsel for people and ensure the protections of the Sixth Amendment are protected. That's
I agree. And I can see this cutting both ways. Like in one sense, this cuts in favor of the judge's decision because the judge may have felt like the judge's hands were tied. But on the flip side, it at least suggests that had bids been ready to proffer a subsequent appointee, the judge may in fact have appointed a new lawyer. I mean, that's how I read it, is that the judge is saying, I'm out of options. If I had an option, I'd appoint you a new lawyer. But since I don't, you're out of luck.
I certainly think both in that discussion where, the warning, the judge is expressing frustration about difficulty in finding appointed counsel. I recognize that this is a smaller, more rural jurisdiction. But ultimately, one, I would remind that there is in fact, a statutory prohibition on our board bids itself from interfering in cases, and recognizing or saying that there is no counsel seems to be a concerning application there. But ultimately there were amongst other things, other public defenders' offices. There are 2 public defenders' offices in Sedgwick County, and counsel.
So what's supposed to
available
happen
for
during
parties.
mid-trial? There's counsel that's been appointed, standby counsel, conflicted off, and then I guess reappointed to finish the trial at that point. But should the court have just said, you're waiving your appearance, we're going to continue on? Tried to find counsel, like you said, there's other counsel available, delay trial. What are the options out there that you think that the trial court should have done?
Well, the first option is appoint conflict-free standby counsel is what should have happened in that situation.
But can I clarify, at what point are we talking about?
Yeah, thanks, Justice Standridge. What I was referring to is the point in which he was representing himself, and then the court found, no, you're being disruptive, you're being disagreeable, and you're basically waiving your appearance the second time, and then standby counsel was appointed to represent him the rest of the way. That's at that point, near the end.
This is during trial? you're
Yes.
Yeah, I think the reality is a court should never get to this situation. If counsel is allowed to withdraw because of a conflict, they should not be reappointed as standby counsel. That's also discussed in the Landeo opinion. It's a number of errors got us to that point, all of which the previous errors were reversible. And I'd like to make one last comment on Justice Biles' original question about what is a district court to do in this situation. I will note a district court has fairly broad discretion in whether or not to actually grant a motion for an attorney to withdraw. That is a fact-specific question, and I think can include concerns about whether or not the defendant has been problematic in that. I don't think that should generally happen when counsel is requesting it, and notes a valid conflict there. The appointment of conflict-free
Well, there's
counsel is the
there's
solution.
I'm sorry, there's a standard of review for that situation, which is justifiable dissatisfaction. And you go through, number 1, is there a conflict of interest? Number 2, is there a complete breakdown of communication? And number 3, I can't remember. Was that process gone through every time through that 7 sets of counsel?
No, generally the motion to withdraw was just granted without very much discussion of it. Often these were on counsel's motion, so it wasn't necessarily Mr. Trass in these situations even.
But frustration is not one of those 3 things. I mean, you're not guaranteed to a frustration-free attorney-client relationship, are you?
Certainly, and indeed, when a attorney accepts the role of taking appointed cases, you acknowledge that there are more limited grounds allowing your withdrawal.
And aside from whether or not, that's not before us, whether those decisions were appropriate. But what is before us is what happened and what she did. Now, let's talk about the defense counsel. The impossible situation. Is there any rule of law that prevents the judge from picking up the phone and saying, hello, respected defense attorney in Kansas, I need an attorney in Hutchinson, Kansas. Will you please take this case representing this person who has had 7 sets of attorneys and is a difficult person? Will you take this case? Anything preventing the judge from doing that?
No, the judge has that authority and.
Doesn't have to work for bids, doesn't have to have a bids contract, right?
Correct.
And in this case, did the judge ever say, look, this is getting very frustrating and it's getting difficult to find attorneys to represent you? And if this behavior continues, I am going to take that. You mean to tell me, you defendant, me judge, I'm going to take that to mean you want to represent yourself. Did she ever say anything like that?
No, no, she did not. The closest we have is that statement within the context of it's getting difficult to find attorneys, that you may be sitting at a council table alone, but there was never any explanation as to what conduct by Mr. Trass would be constitute waiver in the eyes of the judge, or that it would, or again, any of the protections that go along with the waiver of the
Well,
right to counsel.
Did she ever say something that can be interpreted as a warning that this is going to happen, this bad thing is going to happen? I'm going to make you represent yourself. If something, did she ever do that?
No.
Just one final point, because I want to make sure I understand the limits to your argument. If a district court judge in a similar type of situation finds that the defendant, as evidenced by going through 11 different attorneys through 7 sets of counsel, is intentionally obstructing proceedings, that can be a valid basis coupled with appropriate advisements. Would you agree that that can be a grounds for waiver? It's just that's not the case before us.
I think that theoretical situation can come up. I don't think that we, can ever get into this situation where you have counsel withdraw and then the waiver coming up. I think there still needs to be a question of proceeding with counsel. But yes.
Obstruction, it's that the obstruction can be a basis for waiver, in other words.
Theoretically, yes.
Counsel, you've said we shouldn't concern ourselves with the short supply of lawyers. Is there any legal authority?
I believe I cite in my brief the court's statutory authority to get counsel outside of some of the appointment.
But no legal, I mean, no case law or anything.
No.
Okay.
No.
May it please the court, counsel. I know a little bit more about this case because I lived this case for 4.5 years, still living it, relived it when I got ready for these arguments. Just a couple of things. This wasn't simply frustration. This was not simply frustration. If you go back and look, what you suggested, Justice, that she go out and she call somebody and she say, can you do this? She did that on several occasions. Mr. Mon was not a bid's attorney. He was out of Wichita. Contacted him, private attorney asked him to come in. Not a bid's attorney. He worked out a deal with me for Mr. Trass. And then what happened is Mr. Trass threatened to send a disciplinary complaint up to him and to charge him with ineffective assistance in counsel, at which point Mr. Bond said, I can't put my future on the line because this guy won't work with me. And he also indicated that the defendant wanted him to do things that he could not do as an attorney. Then we're looking at Mr. Hebert and Ms. Centeno. Again, Ms. Centeno's out of Wichita, was not on the appointment, neither was Mr. Hebert. She reached out to them. Those were suggestions she'd received of people who might be able to represent this defendant.
You were concerned, right, how this went down, because you repeatedly went to the judge and suggested that I don't think there's proper advisements. I think this defendant's not in a situation to represent himself. I mean, it seems to me from reading the record that you had similar concerns about how this was unfolding.
I did, Your Honor. In fact, the record reflects that I cited a case that the court had just decided a week before that she give these advisements. And I look at that and that would have been really great. If she had done that, maybe I'm not here today in the posture I am if she had. But she was out of options. Justice Stegall, I do want to clarify. She had called Pascalia because she wanted to know if there was anybody who could represent. And there was no one that could represent the defendant at that point in time. And so I don't know about the conversation she had. I think it was probably more like, well, what am I supposed to do now?
So does that at least indicate, or do you think it's plausible that that indicates that had there been an attorney, had that conversation gone differently, that in fact, Mr. Trass would have received new counsel?
That is exactly what it was.
And so if that's true, doesn't that impact the legal analysis of whether or not Trass had actually waived his right to counsel? And to me, it directly impacts that legal analysis.
Well, it is because we went through all of these attorneys.
Okay, so, but follow me here,
Okay,
trying to connect the dots. If in fact, an attorney had been available through whatever means the judge was pursuing, and we agree that the judge would have appointed that attorney, that suggests that Mr. Trass had not actually waived his right to counsel. And if he hasn't waived his right to counsel, don't we have a big problem?
No, I don't think so because it's his actions. She was the point she was at was that she couldn't find.
But we can't put the cart before the horse, is I think at least the way I'm currently looking at it, which means we can't say, are there attorneys before we decide whether or not he's waived his right to counsel? You have to decide the legal question first.
Except for what happened then, Judge, was that's when, and then Mr. Hebert comes in and Ms. Centeno come in, and they file their motion to withdraw. And there's a full-blown hearing on that. And there were hearings on each and every one of these cases when the defense wanted out. And
is that what distinguishes a waiver from forfeiture? That a defendant may want to continue to exercise the right to counsel, but through their egregious conduct has forfeited that right.
right. And in fact, there's another aspect to this that we need to look at. First of all, there's nothing in the record, nothing on appeal that suggests that the defense is saying he didn't do everything he could in his power to drive each and every one of these attorneys away. And so what we're down to is we don't have an attorney to appoint to you. And we told you, and she told him, she said at a hearing, you have excellent attorneys standing by you, and why you would not try to get along with them is I cannot understand. And this is when she appointed Mr. Hebert and Ms. Centeno. We may end up going to jury trial with you sitting there all by yourself because this case will go to jury trial whether you have counsel or not. So she's telling him, you've got to get along with these people. And the thing that we're missing here, if you look at the motions and the hearings on those motions, what he was asking those attorneys to do something they could not ethically do.
But doesn't that happen all the time? I mean, why is that justification for withdrawing? You just say, I can't do it.
My point is though, he was never, ever going to get along with any of his attorneys because none of them could do what he demanded.
Okay, but I think that, I know that one of the issues that appellant has focused on, when I asked earlier, was the whole thing about they should have tried harder to get an attorney. I'm more focused on, the fact that he did, he was representing himself, and was he advised properly before that happened. Now, you've said that prior to Centeno and Hebert being appointed, that the judge made a comment, we don't have an attorney to appoint for you. We're having trouble with this, and that you're going to go to trial, whether you're going to self-represent yourself or not. Okay, so then Hebert and Centeno say, well, he's asking us to do things that we can't do. So we're in a hearing and they're saying that, and he's arguing. He's going, that's not true. you know, and he's interrupting and he's having disruptive behavior. And so he's removed from the hearing. And it's at that point, isn't it, that she says, all right, you guys can withdraw, and I'm just going to tell him at the next hearing that he's going to represent himself.
That's
And then
essentially what happened.
when she, at the next hearing, when she says you're going to represent yourself, he tries to talk and she goes, I don't want to hear it. I don't want to hear you say anything. And she didn't allow him to talk. Isn't that what the transcript reflects?
That's what it's.
Right. And then you say, don't you think we should talk about that? You know, I mean, you say over and over for the next hearings, you file a written motion, you're really trying her to get these advisories and explain what he needs to do. And then finally, when we get to the 7th day of trial and he's like, I never understood what to do. I was never told what to do, all the things that you had warned her about. Isn't that how it went down?
It is, but there's also a point in there that he files a motion to represent himself.
And she says, you don't get to do that because I took it away from you. Right? Doesn't she say, I'm not going to accept that. I'm denying this because I took it away from you.
I don't recall it that happening. I will rely on the record because I don't
Okay.
recall every hearing we had
Okay.
with Mr. Trass. But the bottom line is that seriously, we had nowhere to go. We
It's
had
not
no,
that we had nowhere to go. If you were going to do that, there's constitutional protections as you repeat it over and over and over to the judge, right?
I suppose I'm a victim of my own motions, but that is true.
Of your own ethical behavior.
I did, yes, I did ask her to do that. I don't know why she did not do that, but
Well, if somebody's going to waive their right to counsel by conduct, don't the cases pretty consistently require a warning first that if you do this, I will take that to mean you want to represent yourself?
the only warning he received was the one I cited in my brief, and I'll leave it to the court to determine whether that was sufficient. I don't know what else I can say. I think
But could I just clarify from you were there? It appears to me that the trial court made a specific finding that Hebert and Centeno had a conflict, and it made evident to me that counsel cannot be effective. I think she means advocate for Mr. Trass because of the hostility, and you have my appreciation. And then counsel gets reappointed later down the road. Is that?
really wasn't later down the road, Judge. It was almost immediately he was appointed as standby. Was there
After finding it that
she was desperate to try to make sure he had.
I understand the desperation. I understand all of that.
Some sort of legal representation, and she appointed him there for the entire trial.
And when he was, when he forfeited his right to be in court, he did the jury instructions and did closing argument. Is that right?
He assisted him in submitting the jury instructions, and he did the jury. Conference and.
Thank you.
And when she allowed them to withdraw, it was literally minutes before she appointed him as standby, right?
I think it was maybe in the same hearing. It was either in the same hearing or the hearing that we had with Mr. Trass the following week.
As I understand the record, there was never specifically a finding made that that there were no more attorneys. I think I think I'm out of options, or I don't think I can find any more attorneys, or something like that. Was never definitively,
She said,
there are no more attorneys.
I have no options for appointment, is what she said. And that's on page 19 of volume, I think it's 56. She specifically says, I have no options for. Court wish argument on any of the other issues? Thank you. I appreciate the opportunity to argue for the court.
Thank you, Mr. Stanton. Perkins?
And I do want to start this rebuttal by crediting the state. The state did cite the State v. Jones unpublished opinion that I cite in my brief to the district court as guidance for those proceedings. State v. Jones, of course, finds reversible error in a situation such as this. And the state did file a motion requesting that the district court I believe the language I have quoted, advise the defendant as to the pitfalls of representing himself at trial. The protections of Ferretta and those processes did not occur here. The judge did not fulfill those duties that this court has previously held exist. Again, I don't think the availability of replacement counsel really factors into this decision, though I will, of course, mention that I have been counsel on this case, and on remand, Mike Whalen was counsel on this case. So there has been subsequent counsel available, including at the district court level. But ultimately, I would return to the fact that we are 61 years after Gideon v. Wainwright.
Before you get into that closing, I'm sorry. Do you acknowledge then there is a distinction between a waiver and forfeiture under at least the federal case law, where forfeiture can occur even though a defendant may want to exercise the right to counsel based on the conduct? And it's sort of a different bucket, I guess, where maybe Ferrara isn't going to fit quite squarely in that bucket. But because of that, it's really been reserved for the most extreme of situations in the most disruptive of conduct, potentially when there's a threat presented by the defendant to the safety of others, in that type of situation. And here we've got, tell me if I'm wrong, but it looks like we're trying to fit this into a forfeiture situation that maybe doesn't quite fit that bucket. I know I asked a lot of.
Yes,
that's
I
a
don't
very long
think this
question,
fits the forfeiture bucket. That again is reserved for cases that seems to actually be physical violence against counsel that exist in some of the federal circuits. Not, I don't think all of it hasn't come up that frequently. So it's a conceptual idea, but we're really, I think, yeah, squarely in the waiver by substituting conduct for the verbal consent, which again requires a clear indication to the defendant of what conduct amounts to that consent, that warning. And as is talked about in the Jones and the Landeo opinion about those clear warnings that are required in those situations. Again, we are 61 years past Gideon v. Wainwright when we reach the only instance in our state where we have defense counsel having a motion to withdraw granted because of a conflict. And then rather than appointing new counsel, a defendant is forced to go to trial pro se 2 weeks later. The closest we have are the two cases I have cited, Jones and Landeo in my brief, which both found reversible error in situations that were procedurally speaking less severe and egregious than what happened in this case. And that is structural error. And for that and the reasons further discussed in our brief, we ask that this court reverse Mr. Trass's convictions.
Thank you, Mr. Perkins. That concludes our 9 o'clock cases this morning, and court will be in recess for 20 minutes until 11:05. Thank you.